Ever wondered what happens when a rogue snail meets a miracle cure in court? Get ready for a dramatic, hilarious, and surprisingly educational journey into the heart of UK law, where everyday grievances spark landmark legal battles. A grand, wood-paneled courtroom buzzes with anticipation. The judge, dignified and slightly bemused, presides over a case that has captured the public's imagination. Meet Mrs. Donoghue, our determined claimant. In the UK, the claimant is the person who brings a case to court, seeking justice for a wrong they believe has been done. Mrs. Donoghue, clutching a bottle, approaches the witness stand. She's here because she found a decomposed snail in her ginger beer, just like in the real-life Donoghue v. Stevenson, 1932, case. This pivotal case established the modern law of negligence. Mrs. Donoghue, earnestly, Your Honor, I only wanted a nice ice cream float. Instead, I got a snail and a stomach ache. Enter Mr. Stevenson, the flustered defendant. In UK law, the defendant is the person or company accused of causing harm or loss. He's about to discover that legal language can be a minefield, even for the most careful manufacturer. Mr. Stevenson, resolutely, I sealed every bottle myself. There's no way a snail could get in, unless it was a very clever snail. The courtroom titters. The judge raises an eyebrow, a picture of stern but fair amusement. But today's twist? Mrs. Donoghue is a litigant in person, she's representing herself, without a lawyer. In the UK, a litigant in person is anyone who appears in court without legal representation, often due to cost or principle. It's a challenging path, navigating complex legal jargon alone. Mrs. Donoghue shuffles her papers, clearly overwhelmed. The judge offers a gentle reminder, Judge, kindly, Mrs. Donoghue, you don't need to know all the Latin. Just tell us what happened, in your own words. Suddenly, a second case is called, Mrs. Carlill v. Carbolic Smoke Ball Co. Mrs. Carlill, another litigant in person, waves a newspaper ad promising £100 to anyone who catches the flu after using the company's miracle cure. This famous case, Carlill v. Carbolic Smoke Ball Co., 1893, is a cornerstone of contract law. Mrs. Carlill, pointing at ad, they said they'd pay. I got the flu. Where's my money? The defendant's lawyer tries to argue the offer was just a marketing gimmick. Defendant's lawyer, stammering, it was, mere puffery, Your Honor. The judge sighs, recalling the real case's outcome. The court sided with Mrs. Carlill, finding the company's promise legally binding. The judge then delivers a verdict, referencing the famous neighbor principle from Donoghue v. Stevenson, Judge, everyone owes a duty of care to their neighbor, even if that neighbor is holding a bottle of ginger beer with a surprise inside. Mrs. Donoghue beams. Mrs. Carlill nods in agreement. The defendants look sheepish. So, what have we learned from these dramatic, humorous, and educational case studies? The claimant brings the case, seeking a remedy. The defendant is the party accused of causing harm or loss. And a litigant in person bravely navigates the legal maze alone. These cases, from a snail in a bottle to a dubious miracle cure, highlight how law impacts our daily lives. They teach us about negligence, contracts, and the fundamental duty of care we owe each other. Now that you've witnessed these legal dramas unfold, what do you think? Share your thoughts on these landmark cases in the comments below. Hit that like button, subscribe for more legal insights, and tell us, if you were the judge, what would your verdict be?